as far as if then there's petitions, and then there's victims of crime. There's the whole, we could be here for 2 days talking about immigration. And it's very complex. This is one where they say that the tax code is probably the only thing that's worse than immigration as far as complexity and how it changes. And the unique thing about immigration is that it changes according to the administration, the presidency, because every president, when they come in, they make changes. In this administration in particular, we get changes almost daily on things. And so, we're doing our best to keep up on how things change. So a little background about me. I have been an attorney for over 15 years. I've been doing immigration for over 15 years. I specifically went to law school to do immigration. Did my first year in Florida, transferred to Idaho, where I was part of the immigration clinic there. Worked for Catholic Community Services. I don't know if you're familiar with them. Of the Catholic Diocese in Salt Lake for 12 and a half years. And then went to a private practice for 3, and now I'm on my own, doing my own thing, which is kind of crazy right now, but we'll see how it goes. I've worked with MVMCs for over 10 years. It's been a very long time. I met Letty first. She's the one that kind of connected, and then we've been working together ever since. So I always love talking about this because there's a lot of rumors, especially in the community, amongst the undocumented and green card world, about what's true, what's not. And a lot of the times employers also don't really know what to do, what documents should I ask for, what shouldn't I ask for. So again, this just scratches the surface. There's a lot more that goes into it, but I have my cards here. If you have any questions, just feel free to reach out to me. If you have any employees as well that need some help or have questions, I'm always open. So I split time between Salt Lake and Moab, finding myself more down here, which is great. So anytime, just people can reach out. So we'll just get right into this here. For immigration, we're gonna go through a lot of different things. Immigration terms, we use a lot of slang in immigration that I'm used to saying, but if you haven't been familiar with immigration, you might not know what I'm talking about. If I do use a lot of acronyms, then you're like, hey, if you didn't explain that, just let me know, and I can get into that for you. But we're gonna go over a couple immigration terms that are relevant to employers, and then types of work visas that people can get and apply for. EADs, which we'll talk about what those are. That's technically means employment authorization document, the little work permit, and I-9s. And then a pathway to citizenship. How do people become a citizen? Again, that's going to be brief, but it's a whole world of stuff people can do. And then what are your rights with ICE? If ICE comes to your business, what are your rights as an employer, and what are their rights as a federal agency? So terms to know. So immigrant / IV. IV stands for immigrant visa. So these are people who came in and they're going to live here permanently in the United States, and they had a petition through a family member or an employer. And then they get a special little visa at the consulate. They come in, the minute they come in, they're a lawful permanent resident. And then you also have non-immigrant or non-immigrant visa. Those are people that have tourist visas, temporary work visas, student visas. They're just coming temporarily to visit, to work temporarily, or to go to school. And then we have refugees / asylees, which in Salt Lake, there's a lot. I don't anticipate you seeing very many refugees or asylees here. But refugees or asylees are basically how they're defined is where they were when they got their classification. So a refugee is someone that applied outside of the United States, and they are applying because they are being persecuted by their government or in a government actor or by a group that the government refuses to control based on their gender, particular social group, or religion. And so that's refugee, but that also applies to asylees. The difference is an asylee is inside of the United States, and then they apply for that protection. Asylum right now is incredibly difficult to win. But everyone has a right to do it under the United Nations. Everyone has a right to apply for refugee status or asylum status. So refugees, when they come in, they get a work permit. As soon as they come into the United States, they have to be in that refugee status for 1 year and 1 day, and then they apply for a green card, and then they can apply for citizenship after that. Asylees, generally, if there's 2 ways you do asylum, affirmative or defensive. Affirmative is that you came in, let's say you came in as a non-immigrant on a tourist visa. You have to apply before you've been here for 1 year, but you apply for asylum. You say, I cannot go back to my country. And then you submit your application to USCIS, which is United States Citizenship and Immigration Services. And they have an interview. You talk to an officer explaining why you qualify for asylum status. And then if they deny your case, they then bounce you to an immigration judge, to removal and deportation court, where you get a second chance to explain your situation, your story. The difference, though, is that when you're in immigration court, you can have experts and witnesses and everything, whereas when you're with USCIS, it's just you talking about your case. The defensive is you're inside of the United States, or you show up at the border and get caught by Customs and Border Protection, and then you apply for asylum. And that moves you directly to immigration court, and you don't get that first chance. You're just directly there. Asylees at this point, if they're applying now, are being fast-tracked through immigration court. But I have clients that applied for asylum 15 years ago, 20 years ago, still waiting for their initial interview with USCIS. So it's kind of all over the place. Yes.
Up until a couple of years ago, I've been at the Multicultural Center 14 years. I'd never had a client that was here with a pending asylum application. One. And in the last couple of years, here in our community, I've had several people here with pending asylum applications. And it's not uncommon that, you know, they would show me their paperwork, and it says that they signed that they were explained everything in their understandable language, and they had no idea what any of it said, when they were supposed to file any kind of paperwork. It's all really and above my head, you know, legally. So again, really glad to have good legal resources to refer people to. But yeah, asylum, there's a lot of people here that I think are in a situation that is really hard. They don't know what they're doing or have the resources either. So that's happening here in Moab too.
Yeah, and applying for asylum used to be free. It's no longer free. And so if you're escaping something and then you have to pay for that, so it's difficult for people to apply for asylum. And it's not easy. It can be pretty complicated on how to apply, what you need to do. It's hard when I speak to people from some countries because they're like, my government's really terrible, or they're not controlling like the cartels, right? They're not controlling the cartels, and that's why I need asylum. That doesn't work because the cartels are not targeting that person's for a specific reason. And that's the only way you get refugee status or asylum status, is they're targeting them for a reason because of who they are. So refugees and asylees, there's a lot in Utah. The majority in Utah are from Somalia. And then after that, we get Bhutan and Myanmar/Burma, but mostly in Salt Lake. And then undocumented, someone who entered without permission, or they entered on a non-immigrant visa and they overstayed that visa. So now they're considered undocumented. We prefer that term over illegal alien or illegal, just because it's polarizing at times. So undocumented is the proper term that we prefer to use. Work authorized. These are people who have a valid current work permit, which I'll show you what that looks like in a little bit. So these are people that have the DACA, which is deferred action for childhood arrivals. Those are the kids that were brought in when they were 2 years old, 3 years old, 6 months old. They've been here forever. They're now eligible for a work permit. New applications for DACA are not being allowed to be filed. However, people that had it previously can renew it, and they renew it every 2 years for about $605, I think it is now, to get that work permit. But it's also protection from removal too. It's not a guarantee, because if after you applied for DACA, then you committed a crime that makes you deportable, DACA doesn't necessarily save you. But if you have no issues and get picked up by ICE, DACA does. So deferred action means we're deferring any removal action against you. So, TPS is temporary protective status. That's been in the courts back and forth. I couldn't even tell you what's okay and what's not anymore. I think Haiti, the courts just put an injunction on the government, so people from Haiti are still allowed to continue with TPS, but it changes, like I said, the courts daily. But people with TPS have a work permit. They renew it, I think it's every 3 years, maybe 4, but they renew that work permit. But the government has to say, we're gonna re-register or re-designate your country for you to do TPS again. So the government does have to do that, and they're just not redesignating countries anymore. But it's been fought in the federal courts constantly. So another one, if they have a pending application with USCIS or the immigration court, they can get a work permit. Also, people that are victims of crimes who have a pending application for a U visa or a T visa, they also get a work permit. That means they're authorized to work and there's no questions. They'll get a social security card and have no issues. You as an employer have a right to, if their card's about to expire, ask them for proof that they renewed it or that they have a new one. That is allowed because we need to verify that people are allowed to work. You can only run through E-Verify one time, but you are allowed to say, hey, your work permit's expiring. Have you applied for renewal? Kind of what's going on with that. All right, AOS/485. So AOS stands for Adjustment of Status. 485 is the form. It's I-485, which is a form to apply for a green card. These are for people that have the ability to get a green card. So someone did a family petition for them, like a spouse to another spouse, parent to parent, parent to child. And if they're eligible, which again is a whole other presentation, to do that and apply for adjustment of status in the US, that's what that stands for, AOS or 485. EAD is the employment authorization document. LPR is lawful permanent resident, that's the green card. That means that they are a resident of the United States. They're not a citizen. So there's rules that come along with being a resident. Can't serve on a jury, can't vote, cannot be outside of the United States for an extended amount of time. And you can still be deportable for certain crimes if those are committed. We call them green cards because when it first started, they were green. And then the cards were literally green. And then they went to white, pink, white, and now they're back to green. So that's what that stands for. USC, United States citizen, it can be either by birth or naturalization, which again, we'll go into the pathways of citizenship, but basically if you're a lawful permanent resident, you can apply to naturalize to become a US citizen. If you do, you pass that test, you take the oath, all exact same rights as someone that was born in the US. And then citizen, yep, born here in the United States, from birth, US citizen, nothing has changed about that. You can derive citizenship from your biological parents. So if, for example, if my father was a US citizen, but my mother wasn't, but I was born in France, for example, I could get citizenship from my father if he meets certain requirements. So, and that's different from being a naturalized citizen. That means from your birth, even though you're born somewhere else, you're a citizen. And then naturalization, like I explained, you have an LPR, you're an LPR, apply for citizenship, take the test, answer all their questions, take an oath, and then you're a citizen. If anyone has any questions, just feel free to interrupt me. USCIS is United States Citizenship and Immigration Services. They grant lawful permanent residency. They also grant citizenship. They approve petitions from employers and from family members. They do not do any enforcement. They don't do any removal. That's not their job. They can refer people to EOIR, ICE for removal proceedings to begin, but they cannot initiate them. They can only refer and say, we think this person needs to go to court. And then ICE or EOIR decides if they're going to do that or not. But no enforcement with USCIS. A lot of people are scared to go do fingerprints if they have a pending case. So I go with a lot of my clients to go do fingerprints. I've never once seen ICE there to pick someone up when they do fingerprints, but it has to be ICE who does it and not USCIS. But I go anyway, just because people are scared. And I get that. So ICE is Immigration Customs Enforcement. They are not the police. They're not considered law enforcement, technically. They are a federal agency, but they are only allowed to enforce immigration laws. They can't enforce, like if you're speeding, they can't do that. Their job is to enforce immigration laws, and that's it. And they are in a section of the Department of Homeland Security. That's where they fall under. Same with USCIS and CBP. TSA as well. The one that doesn't is the courts. The courts fall under the Department of Justice. So Immigration and Court of Department of Justice. CBP, Customs and Border Protection. Some people call it parole, but it's protection. And they're the ones at the border, checking visas, checking passports, checking vehicles if people come by land, stuff like that. Technically, they're only supposed to operate within 30 miles of the border, but as an agency, I guess, DHS have the ability to move people wherever they want. But under the law, that's where they're supposed to operate. But 30 miles of a port of entry is what they call it. Technically, Salt Lake City has a port of entry because we're an international airport, so they can operate within that 30 miles. DHS, Department of Homeland Security, again, USCIS, ICE, CBP, TSA, FEMA, Coast Guard also falls under them. The Secret Service, and then anytime that they train like the FBI or whatever, they also fall under Department of Homeland Security. All right, EOIR, just so you know, I mentioned that a couple times. That's the Executive Office of Immigration Review. Those are the people that handle any of the court stuff. The immigration judges, the attorneys for the government, that falls under the Department of Justice and the Executive Office of Immigration Review. So they do all that fun stuff. I don't do deportation. It's too difficult for me. Emotionally, it's too hard for me to handle deport cases, but I do if needed, but I don't do a lot of them. And that, again, is changing daily on how things occur because of federal court stuff. So we're into employment visas, but we'll bring someone here as an employee. There's a common non-immigrant employee options. This is a little chart, which again, I'm happy to share this PowerPoint at any point, but it talks about when an employer needs to sponsor that person and when the person can just do it on their own. So first we have the student visa. F1 is a student visa. They come in to study. Technically, they're not supposed to work. If they do work, they can only work on campus, doing on-campus work for less than 20 hours. However, they can apply for CPT, OPT, or STEM OPT. That's where they focus specifically on what they're majoring in. So then they can get a work permit to work for a company that fits within their major. They don't need an employer to sponsor them for that, but they do need permission from USCIS and get that work permit to be able to do OPT. If they fall out of that, then their F1 can get canceled, and they will lose their EAD if they do DoorDash or whatever on the side. It's very, very strict on that. Also, you can lose your F1 students. Oh, yeah.
I was just gonna ask, because STEM sounds familiar, but like the C and the O before the PT, do those stand for something?
Yes, so OPT is occupational practical training, and then the C is cooperative practical training. So it's just that basically they're saying it's major specific. So but STEM, if you're an engineer focusing on the STEM things, math, engineering, science, then that falls under the STEM OPT. But if I'm, for example, I'm studying to be a teacher, then I could do OPT to be a TA at a school.
Would they have to prove that they couldn't get some kind of employment on campus and why they're seeking those other ones?
No, they're doing it mostly to help with their major. Because if you have
education, you can't
yeah, because if you have an F1 and you're doing OPT, that company, once you graduate, can then sponsor you to become do an it's called I-140, and then you could do an H-1B, EB3, like different things to then be sponsored and then eventually get your residency that way. So a lot of students like to do OPT just to find that employer that's willing to sponsor.
Mm-hmm.
Yeah. And school's not cheap.
Yeah.
So Let's see. Oh, STEM OPT, by the way, yes, does require an employer sponsor for a training plan. They need to say, we're gonna have this person, they're gonna work here, they're gonna do this. We're gonna have a focus on this project or this research project. But OPT and CPT doesn't. They just, if they can find an employer and immigration approves it. All right. EB, H1B, H1B1, E3 specialty occupations. We're gonna get into a little bit more of what those are. But you do need an employer to sponsor those. The employer has to do usually a Department of Labor certificate. And then you have to post the job, you have to show that you're doing a certain wage amount. So that's very employer heavy on that one. The L1 is the transfer. L1s are very rare. You're gonna see those probably never. But L1 also requires a employer. H2A we're going to talk about as well. H2, it's a temporary agricultural worker, people who work on farms, sheep herders. I've done a lot of T visas for people that are victims of trafficking, but they initially came in as a herder, a sheep herder, and then got trafficked after they arrived, but they came on an H2A. O1, these are people of extraordinary ability. Oftentimes they're scientists. Some actors fall under the O. Professional athletes fall under a P. And you do need an employer, but basically you're going to show if you're an actor or an athlete, you need to show for an athlete, you have to show you have a contract, right, with a sports team. For an actor, you just need to show that you have extraordinary ability, and that can be, here's my Oscar. And that's enough to get an O visa. And I know an attorney that he does a lot of actor O visas, and they literally just take a picture of the person with their Oscar and they get it. So H3 or J1 trainees, H3 requires an employer. J1 requires a program. So J1s are, again, we're gonna get into it a little bit. J1s are people that come to work in ski resorts, they're ski instructors. That's a lot of it that we see. Hospitality is a big J, nannies are J visas. So there's some things you need from the employer, but a lot of it is community need or like resource need. TN student status for people from Mexico and Canada. The majority of the TNs that I have seen are registered nurses come in on a TN. And then E1, E2, treaty visas, those can vary. An EB2 doesn't need an employer, but an E2 does. So it gets complicated. The letters associated with it don't really mean anything. It's just where you find it in the law. So it's like INA 2, I think it's 240, 2H, whatever. So they don't really mean anything in particular. So this is another way people come in on B1 business visitor or a B2 tourist. A B1, B2, this is a non-immigrant visa. So they agree, I will go back. I'm gonna go home, I'm not gonna do it. I'm not gonna work, right? My kids won't get enrolled in school. I'm just gonna go visit. So it's short-term business up to 6 months. So a lot of people that I meet get very confused by this. They'll be approved for a tourist visa. Tourist visas are good for 10 years. But when you come into the United States, CBP says you're allowed to stay between 3 or 2 days or whatever, it's up until 6 months. And so people don't realize that 6 months is when they need to leave. They can't stay here. That the 10 years doesn't apply to your time actually inside of the United States. That's how often you can use the visa, but you have to pay attention to that date stamp that's in the passport saying if they say you entered in March, you gotta be gone by September, you gotta be gone by September.
So you would have to apply each time, or like collectively it totals 6 months?
So no, each time. So like so they have the visa,
Okay.
they don't have to reapply for the tourist visa for 10 years. But what it is they technically have to apply for admission at the border by showing this visa.
Okay.
And they say, the CBP officer, I'm going to go see Zion's National Park. That's it, right? And the officer says, okay, great. Here's a stamp. You have 3 months. so they go in.
Okay.
There's a couple of things that can raise red flags for people. They're here more than they are in their home country, and they're gonna assume you're living here. They always ask for, it's called immigrant intent. Was your intent to be an immigrant, or was your intent to be a non-immigrant? If they think you're coming to stay, they're gonna deny your visa, cancel your visa, not let you in. So, and then the business visitor is people that are coming for a conference, or they're coming to meet a company that they're contracted with. You know, it's temporary. They're not planning on being here for a long time. Canadians do not need this visa. Yes.
They usually do this ahead of time, like at the airport when they're coming.
So you have to have the visa ahead of time. You apply for the visa at the US Embassy or consulate. It's called the DS 160, so Department of State 160. And you go to an interview at the embassy or consulate. And if you're approved, they put the visa inside, and then you show the visa at the border. And that's how you come in. They're difficult to get. Visitor visas are difficult to get, especially from Mexico. But not impossible. But basically, when you go to that interview, people just be like, I have a house, I have a job, I have family here, I'm literally going for a wedding, and that's it. You know, you just have to be able to show that. And they'll approve it. The other one is ESTA. Oh, sorry.
Sorry, no, it's okay. I'm just sorry, it's just not clear. So like, if someone, like you said, the wedding example. So if someone's coming over for a wedding, they would still have to do this as opposed to just coming here to travel.
Correct. You have to have a visa from certain countries. Unless you're Canadian, you can come in, right? Or ESTA is the other one that I'm going to talk about. But if you're coming from Mexico, you have to apply for this B1.
So it's
Or
just
B2.
certain countries.
Certain countries. So some countries we have treaties with that they don't need a visa, but they do need to at least register and be like, hi, I'm coming in, right? But they don't technically need a visa unless you're from certain countries. So if you know there's going to be a wedding, you're going to want to apply for this as soon as possible because it can take a while. But ESTA, which I don't remember what that stands for, it's like Europe. No, it's Europe something treaty agreement, something like that. But these are for people in Europe. They can apply for ESTA. ESTA is different in that they only allow 90 days each time. And so if someone wants to come and stay longer than 90 days under ESTA, they would have to apply for a tourist visa. But that just means that they fill out this little form before they plan on coming. Great, they come rent with an ESTA. So that one is also interesting. If you overstay your B2 visa, you get picked up by ICE, you have a right to talk to a judge with the B2 and try to explain why you should be allowed to stay. If you are an ESTA person, you cannot do that. They will just deport. You have no right to talk to a judge if you get picked up and you entered on ESTA. So there's some caveats to go along with it.
How long does the ESTA visa waiver program take? Like if you're wanting to travel from Europe?
Oh, it's like a day. Like you just fill it out online. Yeah, it's just an online little form that people fill out. There's no interview. They pay a fee. So, but that's also why we can go to a lot of European countries without a visa because of the same thing. All right. So we kind of talked about this, but the OPT, CPT stuff for an F1 student, it's a full-time student. CPT is training for part of the student's curriculum. That's what it stands for. It's curriculum practical training, curriculum, something like that. Anyway, sorry. It requires the Department of State authorization. So that means if they apply for this, they also have to get the Department of State to say, yes, it's okay. They get, it's called a Form I-20, and they don't need an EAD for that. That's because it's very specific in what they're doing and it's very temporary. So that's why they don't necessarily need a work permit for the CPT. OPT is post-secondary students. So it's 12 months. It's generally how long that EAD goes and they have to renew it if they're going to do it. And USCIS does give that work permit for OPT people. And then STEM or STEM students, they get 24 months as opposed to 12. And yeah, it's a lot more into it. The 983 training plan is that they have to show on this for these couple of months, they're going to do this. And then these couple of months, they're going to do this. And then, so it's very specific as opposed to, for STEM. And they do get an EAD. The Department of State authorization, and it's called SEVIS. That's really quick. They just put them in this little system, pops out your I-20, and that's where people are able to work. If they need to do the I-765, that's the form that you fill out to get a work permit. If they have to do that, this says 2 months processing times, that technically that's what they claim, but these are taking 6 months or more. The law actually says that USCIS has to issue work permits within 90 days of filing. That's not happening. It hasn't happened for years. They've never been that fast. So. There we go.
I have a question.
Yes.
So what would an employer do then if they had somebody that needed work authorization and they're waiting 6 months? Would it be okay then if the application was in process?
You have to wait for the EAD.
You have to wait for the ED.
Yeah, you have to wait for the EAD, especially with STEM and OPT. Because if you run them through Verify, they won't get anything else, won't have a social until that work permit's approved as well. The difference would be if they're renewing, because renewals are taking just as long, but the receipt for renewing the work permit has an automatic extension. And so that can be used as evidence that they're still allowed to work for at least an additional 6 months while you wait for that card to come.
Okay. And one other thing I wanted to clarify, I get a lot, I think one of the main questions that I have gotten at the center from employers, the main question is, I have this employee, they're so great, can I sponsor them? To get their green card. And all of these visas that she's explaining, it's my understanding they have to apply in their country of origin, right?
Yeah.
So that's my I'm not an attorney, so I can't give legal advice, but it's my understanding that all of these visas have to be, so whoever's working for you would have to apply in their country of origin.
Yeah, which can cause some issues. We'll get into changing status. That's technically what's that called, is changing your status. We'll get into that in a minute, but basically if someone's here undocumented, you can't sponsor them. They have to leave. They have to do it outside of the United States. More than likely they have a bar, so they can't come back for a certain amount of time. They have to do a waiver. There's a lot that goes into sponsoring someone who's either out of status or never had status. So, the only way is to leave if they don't have status. But let's say they're here on an F1, right? They're student, you're like, I want to sponsor that person. You can't at that point because they're technically in status at the time you're applying for them. So, all right, H-1Bs. This is the most popular visa that people have. Again, it's temporary. Generally, people do it for 6 months, leave, reapply. It's a fast process, though. It's not one of those things that drags on for months and months and months and months. It's pretty quick on them approving an H-1B, especially if they've had it before and they didn't violate previously. Specialty occupations, they require at least a bachelor's degree to get an H-1B, or the equivalent in their home country, something that's equivalent to a U.S. bachelor's degree. They also can have a certain amount of time and experience in that field that they're applying for as well, if they don't have a degree. But that involves way more paperwork. And then must have a degree or equivalent in that field. And then it must be directly related to what they're applying for the H-1B. So I can't have a degree in English and apply for an H-1B to come be a nurse, right? They have to connect. The employer must pay the required wage rate, which is listed on the Department of Labor website. It has to be higher or about the same. And then people can only get and renew an H-1B for 6 years. There are exceptions to that, but after 6 years, either the employer needs to sponsor for something else, or they need to move into another specialty type thing. Yes.
I just wanted to add on to that too. Some of you might already know this, but DOPL is adding on to the list of licensures that they are taking foreign degrees. So if somebody came here like on an H-1B and then they were able to stay in some way, that maybe their employer sponsored them, there are DOPL has doubled the number of degrees, foreign degrees that they're able to convert and use here in Utah.
Yeah, that's really helpful. Because sometimes foreign degrees,
Permanent professional licensing.
Oh,
Sorry.
yeah.
You taught Apple, you taught.
You said, yeah.
Professional licensing.
yeah, because sometimes they don't correlate exactly from certain countries here. So, H-1B, it's filing process. Step one, you file a labor condition application with the Department of Labor. Those are quick. They get those back really quick. And then you file the I-129 petition for a non-immigrant worker with that, because when you file with the Department of Labor, that's where you say, look, this is what I'm going to pay. This is what we're going to do. Those would take a little bit of time, but you can pay for premium processing for $2,000 to have them process that in 15 days if you wanted. There is an annual cap for H-1Bs. Actually, April 1st is the first opening of the year. And I know of the employment people, I don't do employment. I know enough about it, obviously, but I don't do it. But all of the employment attorneys that I know, this is their crazy time. Because April 1st, you have to get it in because that cap of 65,000 is usually filled within 12 hours. So it's pretty crazy. If people have a master's, they do an additional 20,000. So, yeah, so people need to establish hiring goals early. So right away say, this is what we need to hire, this is what we need, this is how much we're going to pay, and have that ready to go as soon as that window opens, which again is April 1st. So, if you do premium processing, you can do early in March. Well, kind of. That one's changed a little bit, but yeah, April 1st is when it starts. So it's open for 90 days, it closes, and then it opens again in August, I think. I don't remember, but oh, just kidding. October 1st. That's when it opens again. You can try it again. So there's certain people that are exempt from the cap. They've already been counted previously, so they've already done this one time before, and they're now just renewing. They aren't counted in that cap. These are for new ones. And then universities and government groups are exempt from the cap as well. So. All right, TN and NAFTA. A TN visa permit are qualified Canadian and Mexican citizens. They seek temporary entry into the US to engage in business activities. So the majority of people are going to see on these, like I said, are registered nurses. Because huge nursing shortage in the 80s led to this. We still have one, a shortage of nurses. So that's the majority of people are going to see. There's not a visa limit. There's no cap. They cannot be self-employed. They do have to have an employer though to be able to do that. But they can be part-time, which is rare. Usually they require people to be full-time. And then there's no cap on how long they can renew as well. They can renew forever. And then it's good for 3 years. So they get that for 3 years and they renew after 3 and continue. So like it says, accountants, engineers, scientists, RNs, PTs, all of that. Canadian citizens, no visa is required. Same day processing at the border, which is rare. A port of entry. Or you do it with USCIS. My only thing with that is that I would rather be more sure that I'm getting in as opposed to just showing at the border. So I would probably do it through USCIS if it were me. But and then Mexican citizens, they apply to a US consulate. They can take, I mean, it varies. Some consulates are super quick, some take ages, so that can go all over the place. And then they get it for 1 to 4 years, just for Mexico. But like I said, that's mostly, I mean, the majority of people that use them are nurses. Yes.
We also file with USCIS, but require visa to travel internationally. So if somebody.
So they have to, so that what they're saying is like, let's say that you're here and you have filed for the TN while inside the US.
Oh.
You can do it through USCIS, right? You don't do it to a port of entry. But if you want to travel outside, you have to get that visa.
Ah, so you could apply for a TN in Mexico or Canada or from inside the United States.
But you have to be in status at the time you applied for that.
Okay.
Yeah.
Okay.
Yeah. So like if you have a nursing student, right, and they're like, I want to do the TN, that's going to be a route that you would do. I mean, I'm like 90% sure that that's true, but I can double check on that one. I've seen some TNs, but they're super quick to get, and most people just go to the border because they're like, there you go. At least from Canada. Mexico, you have to do the consular processing. Yes, all right. O1 or PNPV says these are the people that are top of their field. They're the super fancy people. They have an extraordinary ability in science, arts, education, business, or athletics. With sustained national, international acclaim or extraordinary achievements in motion picture, television industry. PVs are professional athletes. Processing, same process for both of them, but processing times vary. I don't know if you ever are watching like a sports and they're like, the person's not here because of visa issues. It's this thing. They're good for 3 years. They can be extended indefinitely every year after the 3 years. And so, yeah, physicians, researchers, company executive, like I said, athletes, artists. And you file the I-129 with USCIS and a consular, and then they go to the consulate to get the visa to come in. They're fast. They're actually really quick on how they do these. Sometimes they get hung up every once in a while. With the current country pause that they have, that's affecting some of the athletes coming for the World Cup. Technically, there's a carve out for those people that are coming as soccer players for the World Cup, but there have been a couple countries where they've been denied this P visa. So, because of the pause. All right. J1 interns, trainees, and exchange visitors. So they are coming to do a work study based program. They're sponsored by an exchange program, and then Department of State has to designate that program as one that's allowed to do that. So like snowbird, they're allowed to do J1s for ski instructors. Let's see, they do a training plan saying this is what they're going to do. That's if they're also doing study. They're doing study along with. So I've had a couple J visas where they're coming to do hospitality work, but they're in an English class at the same time. So, and then J visas tend to have, they're kind of changing that a little bit now, but they can have a 2-year return to country requirement. Meaning after they've completed their J1, they cannot come back on a J1 again until they've returned to their country and waited there for 2 years. And then they can come back on a J if they have that restriction. I can't even tell you why some people get a restriction and some people don't. It used to be very specific to a certain group of people, but now it just seems whoever might get that country restriction to return for 2 years. You can waive that. I have done waivers for those. Lately, though, even if the country, so what you do is you can do a no objection waivers where your country says, we don't object to them not going back. They can stay there. We don't care. As the country of Western Samoa, you don't need to go back. We're good. However, you have to send that to the Department of State, and then the Department of State decides if they want to grant that waiver or not, even if they have the no objection, and they are denying all of them currently. So they're making people go back for 2 years. There's other things too. You can do hardship to a family member is why you can't go back to. But yeah, these are for private sectors. You apply at a US consulate overseas, and then wait times just depend on that consulate, how long it's going to take. You'll see a bunch of these mostly for the hospitality industry here in Moab. H-2As is another big one that we see. So temporary agricultural visas, they're coming to work, farm, ranch, fields, something like that. It has to be temporary. You have to show that the contract says you're only going to work here from March until September. That's it. And then go home. You can renew that though. I know I have plenty of clients that every summer they're back here working in the farms and stuff. Yeah, obviously it has to be agriculture. You can't get an H-2A and then work in a restaurant. It has to be agriculture. Farm workers, livestock workers, equipment operators. This one, like I said, is a huge one. You need to be aware of victims of trafficking. The majority I mean, at one point when I was doing T visas, the majority of my clients were victims of sex trafficking. And then it switched to victims of labor trafficking, and the majority were farm workers. They were promised certain things, but they didn't get that. They weren't paid like they were supposed to. Because the employer has to say, I will pay for your housing and I will pay for transportation. But what happens is sometimes employers say, but you have to pay me back. They're not allowed to do that. Part of an H-2A is your employer says, I will provide this stuff. I've had clients live in really horrible conditions. I had a guy he lived in this little trailer in the middle of nowhere caring for the livestock, which is fine if it was a good place to live, but they wouldn't give him water. He had to drink the same water as the cows. The fridge leaked so bad that he got really sick from the stuff that was leaking out of it. And the employer told him that if he went to the hospital that he would call ICE. He has a T visa now, so he's okay. But that's one we have to be really careful with H-2As.
I have a question on that.
Yeah.
Given the fact that I am in law enforcement and we run across this, where would we refer them to? My guess is a lot of them don't know that they're eligible under those conditions to get a different kind of visa. So
Yes.
where would we?
Any immigration attorney, like I said, I do a ton of visas. There's unfortunately not a group that does specifically T visas. So like U visas, there's a bunch of nonprofits that will help for victims of crime. But T visas are just not a lot of groups, but.
We had a presentation from Utah Legal Services yesterday, and they reminded us that they are specifically have their migrant worker free legal.
That's true, they
services
do.
for
I forgot about them.
Where was that again?
Utah Legal Services,
Okay.
and they'll do free full representation for migrant workers
Yeah.
in Utah.
I
Okay.
forgot about like Utah Legal Services. Yeah, they also, Utah Legal Services is good because they offer therapy and housing assistance. I also know Asian Association used to do a bunch too.
I don't know if they do.
I don't know if they still do.
Sure.
I know at one point they did. There's also a pretty well-known attorney. His name's Alex McBean. He does a ton of T visas. He's private practice. That's basically all he does, T visas. So, and there's a lot of the time people don't realize, like I had a guy, he was brought in specifically to show people how to be a good sushi chef. So hard to say, sushi chef. But then his employer would make him clean his house, do his yard work on the weekends, never give him a day off. And he was like, is this a problem? He also took my passport. That's your first red flag. If the employer takes the person's documents, that's when you start asking a couple other questions, because they're not allowed to hold their documents. And yeah, a lot of people don't realize that they're actually being trafficked. So all right, H-2B is another big one. Temporary non-agricultural visas. So a lot of these that we see, construction workers tend to have H-2Bs. Temporary in nature, seasonal need, peak load need, intermittent need. So if you're bringing people in because there's a new housing development being built, H-2Bs is a big one for that. Again, it's a numerical cap. 66,000 who apply in April and October. And it's limited on what countries can apply for an H-2B, but that can change. That's why I didn't list the countries, because it changes. So, all right. So things to know: applicants cannot change from one status to another unless they are currently in status. So if I came on a visitor visa, overstayed that visa, I can now not apply for an F1 because I'm out of status at that point. Undocumented employees cannot apply for a work visa while in the United States. They must consular process. And they need a waiver to allow them to come back. Usually that's a 601. So the law says after 1998, April 1st, 1998, if you're over 18 years old and you've been here for more than 1 year without permission, and then you leave, you're given a 10-year bar. You cannot come back for 10 years. And people need to file it's called a 601 unlawful presence waiver outside of the United States. However, the only people that qualify to help you do that waiver are if you have US citizen or lawful permanent resident parents or a spouse. So if you don't have that, you don't get to do that waiver and you're stuck for 10 years. It also varies. If you were here, overstayed 8 months and then went home, you only have a 3-year bar. But once you hit that 1 year, it's a 10-year bar. So there's also, it's called a permanent bar. If at any time, even if you're under 18, over 18, doesn't matter. If you were here in the aggregate of 365 days, so you were here for 6 months at one time, 9 months for another time, and then left and then came back illegally, you get the permanent bar, which means there is no waiver for 10 years. You have to stay out for 10 years and then you file a waiver to come back. And that applies to kids, which is horrible for me because, you know, little kids, they have no choice over what their parents decided to do when they were younger. But unfortunately they have the perm bar. So it's absolutely have to be outside the US for 10 years and then file for the waiver. There are visas that do lead to the LPR on their own. So employment-based preference, first preference, second preference. These are the EB ones, which oddly enough, EB stands for employment-based. That one doesn't match. EB 1, 2, or 3 or perm cases are professional employer. I don't remember, but it's like EB 2. It's basically you have a sponsor. EB 1 I-140. Involves a sponsorship for an employer filing the I-140. Some require the labor certificate, some don't. It just depends on what you're applying for. And then all of those fees, as far as the I-140, Department of Labor, all of them are paid by the employer. You can't require the employee to pay them. If you're planning on sponsoring, you're fully sponsoring. All right, any questions about H-1B? Yes.
When family petitions, how if you're sponsoring a family member to adjust status, that you have some financial responsibility that they can't apply for public benefits for a certain amount of time. Is that the same when an employer sponsors?
So
they have a financial responsibility?
They don't have a financial responsibility, but they do have the responsibility to pay for all of those fees. They do have the responsibility to provide a living wage, right, and all of that. Also, for some of them, the person is required to continue to work for that company until they get that green card. But there's so when you do a family petition, it's called an I-864, where the person asking for that person to come has to show that financially they can take care of this person. You provide taxes, W-2s, all of that. You don't need that with an employer-based sponsorship because you're doing other stuff. So, I mean, sometimes employees are stuck with that company for a really long time because they have to wait for a visa to be available. And there's a thing called the visa bulletin. And if you ever look that up, there are sections EB1, EB2, EB3, and that says when a visa is available because of those caps, right? And so people will have to stay with that company until that visa becomes available and they can adjust status. And so that can be difficult for the employer at times, it can be difficult for the employee, especially the employees like, I have a better job over here, but if you leave, you can lose that I-140. But that depends, right, on the job. So, all right, employment authorization document and I-9s. So work authorized. We kind of went through this previously a little bit. People that have the work permit, but also naturalized citizens, permanent residents, US citizens, all authorized to work. So deferred action for childhood arrivals, if you look at this is the employment authorization document, that's what it looks like. And if you look, you can't really see this very well, sorry. Right there's a category, it says why they're eligible to work. It's a little blurry, I apologize. But there's certain ones, these are the most common. There's a bunch of other ones that people could be qualified for, but DACA, you're gonna see C33.
But they're still the same.
Oh, sorry.
They've always been, they're like driver's license.
Yep.
Size.
Yep.
Just curious.
Yep, just driver license size. TPS can be A12 or C19. Asylees and refugees, C8 if they have a pending asylum claim, it's a C8. A5 if they're approved asylum, A3 is a refugee. That's never going to change because refugees come in as a refugee, right? They don't have any pending things. They have a pending adjustment of status, that's going to be C9. So T visa victim of trafficking, that's a C40 while their case is pending because these cases take a long time. They're willing to give them a deferred action, temporary one, that will be C40. Once it's approved, you'll see A16 for the principal. So if you have a T visa and they have children or a spouse, they're allowed to be on that same case. They're called derivatives. So they'll be the derivatives on the case. So they'll have C25 if spouse was part of a different case. And then U visas and VAWA. So a U visa is someone that was a victim of a qualifying crime. Not every crime qualifies for a U visa. And they called the police and they assisted in that investigation of the crime that was committed against them. Qualifying crimes are aggravated assault, domestic violence, extortion, kidnapping, sexual assault, things like that are a qualifying crime. And the police sign a certification that say, yes, this person is a victim of a crime, the crime is qualifying, and they were willing to help us out. That certification is only good for 6 months, and the person applies for a U visa. They also can include other family members as derivatives on that case. The other thing too is if the victim was a US citizen child, then the parent can step into the shoes of that child and be the victim and get a U visa, as long as the parent helped in that investigation of what happened to their child. The U visa is taking about 10 years. They have a cap of 20,000 every year, but there's 120,000 people applying every year for U visa. So you're waiting 10 years. So the majority of the U visa people are going to have a pending one, which is C14, that work permit. Even that's taking about 3 years to be able to get that work permit. The other thing is too, I have had police departments say, well, we never prosecuted this case, so we're not going to sign the cert. That's not what the law says. The law says they helped in the investigation or prosecution, not both. Yes.
Do you know if victim's advocate would have this information?
Mhm.
Okay.
They should, and if not, I've done presentations with police departments on that too. But usually if I have a victim and they say, hey, you know, I called the police about this, I always refer them to the victim advocate. Because they
We run into that's pretty common.
Yeah. Yeah, U visas are huge. I can't even tell you how many I've done that have been really, really good for people.
Okay, and Utah Legal Services would also be same for the T as the U.
They don't do a ton of those. Catholic Community Services does, Holy Cross Ministries does, Rihanna helps with a lot too. We do a lot in connection. We've done a lot of U visas lately.
I think, you know, right now, because it takes 10 years, if people, Emily does them really affordably. So, you know, I'll do an assessment with somebody and talk to them. If they're able to hire a private attorney who can, you know, follow that for the next 10 years, it's really, really great if somebody can hire an affordable private attorney for a case like that. But otherwise, Utah, you know, it's charitable services for those cases can be, it's hard because, you know, yeah, if someone's doing it for free, the turnover in that organization is oftentimes is hard when you're getting legal aid that's free.
Yeah.
So you really need somebody who's going to follow your case over a really long period of time. So if they have the ability to hire a private attorney, it's great. And when you work with an organization like mine, what I usually do with a case like that, I have a relationship with the sheriff's department, the police department. So I would, you know, help the victim in that case get the certification signed, and you know, kind of it's uncomfortable to bring up crimes, and you know, these are very traumatic things usually that happen. So and it's hard to revisit that and have that conversation with you know, in the formality of a police agency. So just going with somebody and helping them get that paperwork signed is something that I can do.
Yeah. I've done, I will, usually if someone hires me, and like Rana said, I try to keep my costs as low as I can. I also let people do payment plans. I have someone right now paying me $50 a month because that's all I can afford at this point, which is fine. I'm fine with that. Because a lot of it, I want it filed. I want them to have some protection. So I will usually contact the police department myself, unless like Rihanna has a really good connection. I'll use her because they don't know me, right? They don't know if I'm a good attorney or if I'm a bad attorney. So if I have those connections, I'll use those to try to get those certifications signed. So, but U visas are huge for a lot of people, like life-saving for a lot of them. The other one is the Violence Against Women Act, which is not just women, men also apply for VAWA. But the technical term is VAWA, is violence against women. That's the act. But these are for people that are married or were married to a US citizen or lawful permanent resident, and then they were abused. A victim of domestic violence. It does not have to be physical abuse. It can be verbal, it can be financial, emotional. There does not have to be a police report for VAWA, whereas it does for a U visa. There does not have to be police involvement with the VAWA. You show that I'm married to this person, this is how they abused me, and this is what happened. If there's not a police report, I always make my clients go to a therapist, because if they talk to the therapist backs up what they're saying. Therapists are trained, right, to know if someone's a victim of abuse or not. And so they send me an evaluation, say, yeah, this person is clearly a victim of abuse. And that's what you do to file a VAWA. If someone is divorced from that lawful permanent resident or US citizen, they have to file that VAWA case before the divorce hits 2 years. So that's another big thing that I've had people married, but they divorced 6 years ago, so we can't see VAWA. But those cases, you're going to see C31 for a approved U visa, or I'm sorry, for VAWA if it's approved, A19, A20 for a U visa, and then there's a bunch of other ones, but the US, these are the most common ones you're going to see. So that's the document. They're always going to get a social security card when they apply for a work permit. There's various types. A restricted social security one is the one at the bottom. It says they're only valid to work with DHS permission or authorization. This means that they have to show this social security card with their work permit. They have to show both of them, or else they're not able to work and you're not able to hire them unless they see both at the same time. Unrestricted social security, if someone shows that and their driver's license, or I'm sorry, that one, and their driver's license, you're not allowed to ask for any other documentation. Because it's unrestricted, they're showing 2 forms of ID, social security, and their driver's license, that's it. You can't ask for anything else. And then if it says not valid for employment, obviously they're not valid for employment. Students sometimes get this one depending on what they're doing. If they do get a work authorization after that, they just need to ask for a new one that says, I need the restricted social. I also have a lot of clients after they get that green card, I tell them to get rid of this one and go to that one. So then they no longer have to show their green card to work. They just get to show driver's license and their unrestricted social. Number stays with them forever, obviously, right? Once you get it, it's yours. Doesn't change. And in theory, USCIS is supposed to send the work permit and the social security number together because they're supposed to be working with the social security office. That is not happening lately. So we've been telling people just contact the social security office once you get your work permit and they'll issue it. All right, so I-9s. It's required for all US employers since 1986, yeah, to do an I-9. So first section, the employee attests to personal information and citizenship. They have to show status on the first day or first day of work. The employer verifies the original documentation and they have to show their identity, you know, their proof they're eligible to work within 3 days. And then they must re-verify employment. E-verify is not required. You're not required to do that. The Senate, the Utah legislature tried to pass a thing that they said, we want businesses of less than 20 or more than 20. Now all are required to do E-verify. That didn't pass because a lot of construction people were like, that's never gonna work. I think it's if you have a business over a certain amount of time, you do have to do E-verify. So like if I apply for Walmart, if I do it online, they're gonna have an E-verify section because it's a huge employer. But smaller employees don't have to do E-verify. EADs are taking a very long time. And so if the person needs to renew their EAD, they need to do it at least 6 months in advance. And then once they get that receipt, it's the extension starts the day that the EAD expires, not the day they applied. So once it expires, it extends for another 6 to 12 months, depending on their category. All right, this is a big one for me. If you're filling out the I-9 for someone, do not ever mark that they're a US citizen. If someone claims to be a US citizen, it is automatic deportation and there is no waiver for that. The only way you can waive that is through a judge or a U visa. That's it. And so some employers are like, oh, I'm gonna help you out, I'm just gonna fill this out. Even if the employer fills it out, but the client signs it, USCIS says you attested to the truthfulness of that I-9, so you claim to be a US citizen. So never, ever do that, please. And then also check their application, make sure they didn't claim to be a US citizen either. I try to tell that to community as much as I can. Don't claim to be a US citizen. I don't care if you have a fake social, I don't care. Don't claim to be a US citizen. And then I-9s are to be retained while the person's working there, right? You're supposed to keep those. But if they're no longer working there, you only need to retain for 3 years after the date of hire, or 1 year after the employment date ends, which whatever one is later. So work for 6 years with the company, then they leave. The I-9 only needs to be retained for 1 year after the last date of employment. And then you do not need to keep a copy of their ID or work permit. The I-9 technically is what verifies that for them. If the employee is undocumented, I as an attorney cannot tell you what to do. That's your decision. It's up to you. I do say if you want to, I hire them as a contractor, give them a 1099, then you don't have to worry about the I-9 stuff. I have a lot of clients that technically have their own business, and you can have your own business with being undocumented. There's nothing that bars you from doing that. But I have a lot of people like, well, how do I hire? Being a contractor, 1099 is the best way. Choose to pay in cash, that's up to you. It's not anything I should tell you. I can tell you to do, not to do. That's your decision. I'm not here to give that advice. But the biggest thing is don't mark US citizen if they give you a social. So, any questions? I-9s, EADs? No? Okay. And like I said, if they have their restricted social and their card's about to expire, you have absolutely every right to say, where's your new card? Where's your receipt? Have you renewed? Right? That's allowed. Oh, sorry, yes.
So even in that case, if they have one of the visas with an approved visa number and have the social security, you still wouldn't mark US citizen.
Right, because there's a section that says authorized to work. Yeah.
So you would check that.
Yeah.
Okay.
So there's US citizen, lawful, or I think it's just US citizen and authorized to work. I think it's one of those, I don't remember, but I should have put that on there. I didn't put that.
I'm like, I don't know for me.
I feel like I looked at it and I was gonna add it and I completely forgot. But no, I think it's broken down into, it used to be US citizen, US national. And we could always argue, well, they thought they were US national, not citizen. But now that's divided. And so now it's US citizen specific. I think it says lawful permanent resident and then authorized to work. So you would just mark authorized to work. Yeah. All right, pathway to US citizenship. How do people become citizens? So undocumented to lawful permanent resident, you can do it under a family petition. This is an I-130 petition filed by a US citizen or lawful permanent parent, US citizen or lawful permanent spouse, US citizen child, or US citizen sibling. So a US citizen or a lawful permanent resident cannot petition for a brother or sister. They also cannot petition for a parent. They need to become a US citizen first for those two. US citizens can petition for almost everyone except for nieces and nephews, grandma and grandpa, right? But they can do brothers, they can do brothers and sisters, spouse, child, parent. The thing that goes along with that, if I am a US citizen petitioning for my brother, he's married, has 6 kids, all of those people can be connected to the same petition and they all can come together when the visa is available, which unfortunately is about 15 years from now. But you have to wait for a visa to be available to get that. It's pretty complex. It depends on the beneficiary and how long they're going to wait. if they can do it inside or outside of the US. And then how long, yeah, the wait time just completely depends as well. Sometimes people can do it in the US if they entered on that visa, right? If they came on that B2 and then they married a US citizen, they can file inside of the United States, they do not have to leave. But if I'm petitioning for my brother, his only option is to consular process. He has to do it outside of the United States, even if he's here. So, unless he's in status. So like, let's say we have all of that, we did all that, the visa is finally available after 15 years, and he happens to be here with his family and they're visiting, they're still in status at the time the visa becomes available, then he can do it inside of the United States. But if I'm petitioning for my spouse and they overstayed their B2 by 15 years, they can still do it in the US. So it's complex, it's confusing. Talk to an attorney. And then if the employee can file through a family member, if the employer wants to sponsor someone, they want to help someone do the I-140, talk to an immigration attorney, because that can get complex. You have to know when to file, when to do it, stuff like that. Work petitions, I-140 petition filed by the employer, depending on the type of visa. Employer pays those fees and wait times vary. That's another one that for some EBs, they have to wait for the visa to be available. It's called the visa bulletin. And I want to say, like, from Mexico, it's probably 6 years, I think, for certain ones. So, I mean, Congress could change that. At any point, they could say, we're going to allow more visas every year, and they just haven't since 98. So, and then victims of crimes or trafficking. So this is, again, U visa. 7 to 10 years, they get a work permit after 2 to 3. Once they get that U visa, it's good for 4 years. They have to be in U visa status for at least 3. Once they've hit those 3 years, they can apply for lawful permanent residency. Once they have that green card, 5 years, they can apply for citizenship. But they have to be in that status for at least 3 years. Same with the T visa. They also have to be in status at that same time. VAWAs are a little different. If the person was married to a US citizen, when they file for the VAWA, they can file for that green card at the same time. If they were married to a lawful permanent resident, they have to wait for a visa to be available. So it's a little different with the VAWA case. The big thing between VAWA and U visa for me is that U visas are willing to forgive or waive any sort of issue. It's discretionary, it's up to the officer, but if they entered, like for the example of the permanent bar, a U visa can waive that permanent bar. They can say, we're not going to worry about it, we're going to do it. VAWA cannot. So you can't do a waiver for things like that with VAWA, but you can with VAWA wait times are about 4 years. That's about how long they're taking right now. They have to approve the VAWA first, and then they'll focus on the green card application. So it's about 4 years. U visas and T visas are never interviewed. VAWA cases are always interviewed. However, at that interview, they're not allowed to ask anything about the marriage or the abuse. They can only ask questions about the green card. Yes.
VAWA also maybe abuse from a child to a parent.
Yes.
That's that too.
Yes. So US citizen child can abuse a parent, but the child had to be over 21 when they did it. Oh, but they can. We have a couple of those. We also have this attorney in Texas that tells everyone that they can apply for a VAWA, and he's now been flagged by USCIS for that. So no, it's specific when it comes to a parent. Usually with parent cases, I have a police report, but you have to show the kid was over 21 at the time they did it.
So like elder abuse.
Yeah.
Basically.
Mm-hmm. Yeah, and then like a child can claim abuse from a US citizen parent as well. So
Thank you.
all right, so this is how it goes. You apply for your green card. The card's valid for 10 years. There's a caveat to that if you're married, but that's another thing. You have to maintain US residency, meaning you cannot have any trips over 6 months, and you cannot have more time outside of the United States as in. If you never want to apply for citizenship, you can go longer than 6 months outside the US, but it has to be less than a year. If you're gone more than a year, they can take your green card away for abandonment. Say that you abandoned your residency. Cannot vote, cannot serve on a jury, any of that fun stuff. Benefits, They don't have to do any other status. You can't really read that, sorry. No issues with employment. Again, you'll have the unrestricted social, get a regular driver's license, you're good to go. And then travel without a visa, depending on the, into the US, travel into the US without a visa. So if you have a green card, you show your passport from your country, green card, come in. You get to go to the second fastest line. First fastest line is US LPR visas, generally, the airport. And then apply for naturalization. They have to be a permanent resident for at least 5 years to apply for that. Unless they're married to a US citizen, then they can do it in 3. But you have to show that for the last 3 years, this person has been a citizen and we have lived together and we've been married for at least 3 years. People also have to show they have good moral character. So everyone has to do a fingerprint. They run it through the FBI rap sheet. I have a lot of people that think if they got it expunged, then they're fine. Absolutely not. Nothing's expunged for immigration purposes because they use the FBI and you can't expunge that from the FBI. But the problem is if you expunge it and it looks bad, the original charge that shows up on the FBI thing, but you can't prove that you were not convicted of that, then you're in some trouble. So expungements, always contact someone first. So they have to have continuous residence in the US. Like I said, no trips over 6 months, cannot have more time outside the US. I have people that travel all the time and I make them list date left, date came back, how many days, and we count it all up. And if it's more than 913 days, they have to wait. They cannot apply. And then language and knowledge test. In October, they changed that test. It used to be 100 questions. Now it's 128 questions. At the interview, they'll ask them 20 and they need 12. Yes, you have to have 12 correct to pass that test. It's in English. There are a couple exceptions. If someone had their green card for more than 15 years and they're over 55, they can do it in their own language, but they still have to study those questions. If they're over 50-20, so 50 years old, have their card for over 20 years, again, they can do it in their own language, but still have to study the questions. And then 65-20, over 65, have their card for more than 20 years, can do it in their own language, but they can also do a modified shorter test. And they can have an interpreter. Usually you're not allowed to have an interpreter because you have to show that you have the ability to speak English. Also, people that have medical or mental disabilities can do it. It's called N648 to waive the requirement for this test. Those are generally people who have dementia, Alzheimer's, short-term memory loss. PTSD is a big one. People have a difficulty learning things when they have PTSD as well. A lot of my refugees did those because of stuff that they went through in their countries. You go to a USCIS officer at the local office. They usually do the test first. If the person doesn't pass the test, they have 60 days to study and then they'll go back for a second chance. So you have 2 chances to pass. But like, let's say I passed reading and writing, but I didn't pass the civics. When I go back the second time, I only have to go back for the civics test. So. Once you're a citizen, you are a citizen. Technically, immigration can try to revoke your citizenship, which in the news has said that that's what they're going to do, but that is not easy for them to do. It requires a federal court case. It requires a federal judge. It's not something that they can just, we're going to take your citizenship away. They can't. They also have to prove that you committed fraud at any point along your line of green card to citizenship. And again, that's really difficult to do. Revoking citizenship is not something that they do often, even though they say they want to do it more. It's not something that's easy. So if people are freaking out about that, I wouldn't worry about it. All right, so that's how people get to citizenship. Like I said, once they're a citizen, they're a citizen, so have the same rights of people that were born here. Employer rights with ICE. What do you do if ICE comes? So there's 3 ways that you can interact with ICE. I-9 audits, workplace raids, or they're coming to detain someone specifically. So I-9 audits. ICE and DHS cannot just come to your business and say, show me your I-9s. They have to serve notice that that's what they want to see. You have 3 days to respond. You don't have to give it early. You can give it to them right on that 3rd day. And then you only have to turn over the documentation that they requested. If they said, we want to see all I-9s, you don't have to give them applications. You don't have to give them copies of anything else that you may have, just the I-9s. Always make copies for yourself of what you gave them. And then just consult with an immigration attorney to make sure that you're following exactly what they're asking and not doing less or doing more than what they're requesting. And then again, destroy old I-9s following the 3-year or 1-year rule. Worksite raids. These haven't been common for a really long time. I think the last time worksite raids were happening was a little bit in Obama and Bush. They could pick up, they might not, I'm not sure. But basically they come to your work site without warning. And they're investigating an employer. They are not police officers, but lately they've been having police on them. They may carry guns, they're allowed to do, obviously. Sometimes local police officers or agents go with them, but there's not, it's called a 287G, right? I have an issue with numbers. 287G agreement where ICE can deputize local police agencies to be ICE officers. Moab does not have that agreement, and Grand County does not either. So if the police are there, it's usually because they also have their own separate thing, their own separate arrest warrant, their own separate search warrant apart from ICE, unless that agency has a 286G agreement. And I would confirm, 1, that they're ICE agents. 2, that they have the legal authority to enter your premises. There's a difference between administrative warrants and judicial warrants, which I'll show you the difference in a minute here. If they have a judicial warrant that allows them to enter your business, it'll be signed by a judge, and it has to be specific on what they're looking for and where they're going to go. So if it says, we are going to look at this warehouse, but then they go warehouse B, you can tell them no. The warrant does not say that, right? As an employer, I always have the right to give them permission to enter, but if you don't want them to, just follow that warrant. Only a designated point person should communicate with ICE. It's can be crazy if you have multiple people trying to say things because there could be cross communication and everything. So I would just have one person that's in charge of what's going to happen there. Document everything, names, badges of ICE agents. That's mostly for your protection, just to make sure everything's okay. And honestly, the officers' protections as well. Advise employers to remain calm, don't run, just stay and we'll figure it out, we'll work it out. They don't have to answer any questions to ICE, they're not required to. I usually tell people there's a lot you can remember if you get picked up by ICE, but 3 important things is have a phone number memorized that you can call if you're family or friends. Don't sign anything that you do not 100% understand. Ask to talk to a judge. Big main three things for people. Because if you have the family member, they can then contact an immigration attorney to work on that. Signing something is, I've had clients that speak Spanish, but they were given a paper in Portuguese and they just signed their deportation away and they didn't realize that's what they did. And then the third thing is talk to a judge. They might have forms of relief. They might be able to argue with the court as to why they should be allowed to stay. So, yes.
And the most common thing is they will likely be searching for a specific person. So the most common question is, can I see your ID or who are you? And 9 times out of 10, they'll say thank you and I'll be on the way.
Yeah.
9 times out of 10.
Right.
They're not the person that they're.
Yes, if they're specifically looking for someone, yeah, that's what's gonna happen. A worksite raid though, that if they don't see work permits from people, they technically can round up everyone. There's a lot that we do as for what happens if ICE comes to your house, right? What do you do there? It's very similar. They're not allowed in unless you allow them in. So, I would not immediately hand over all of your records. I would say specifically, what are you looking for? Right? Also, where's your warrant? Which could be scary, especially if someone with a giant gun is like, give me your stuff, right? But you have rights. Don't lie to the officer or interfere if they are arresting someone, because that gets you in trouble and it can also hurt the person that they're arresting. But don't give them access to non-public areas. If they don't have a warrant, they're not allowed back there. So they're allowed in public areas, obviously, right? Everyone is. But a non-public area, just don't let them back there if they don't have a warrant. For third-party work sites, like if you're a contractor and you're working in a house, make it clear to the officers it's not your primary work site and tell them to go to the company's management or whoever's in charge of all of that stuff. The other thing is I would make it clear on what is a public area and what is a private area. So at your workplace, you know, say employees only, private area or whatever, just so it's very clear that they don't walk in there not knowing that they're not allowed back there. So difference between warrants. This is a warrant signed by a judge. It's very specific on what they're looking for or who they're looking for. Always signed by a judge. And if not signed by an immigration judge, it's signed by a district court judge, a justice court judge, something like that. So that's what a judicial warrant looks like. This is an administrative warrant. It's going to be signed by an ERO, an officer of ICE, an ICE officer, or it could be signed by a judge, but an immigration judge, which is different than a judicial warrant. It's going to have, you know, specifically, we're doing this because this person needs to be removed or whatever. The biggest way to know if it's an ICE warrant is if on this page, you see a photo and a fingerprint. Easiest way to tell if it's an ICE warrant as opposed to a judicial warrant. So it's only for the detention of a specifically listed person. They can't use this ICE warrant to pick up someone else, right? It's just for that one person. They can't enter private places or workplaces if it's a private area. And like I said, they have to show this. You have every right to ask for it, to see it. And I mean, be as cooperative as you can, but also you do have rights, right? When it comes to your workers and when it comes to your workplace. People are going to be scared, but like I said, don't ever tell people to run or hide. It's going to be worse for the person and for you. So if they're coming to detain a specific person, they'll have a warrant like that one. Ask to see the warrant for the person and make sure it is signed, because that is the other thing that you have to sign it or it's not official. And then, like I said, it can be signed by an ICE supervisor. It doesn't have to be the specific officer that's there, it just has to be signed by someone from ICE. Verify the name in the photo that they're looking for, that they're claiming to detain. You don't need to allow them into your business if they're looking for someone specifically. You can tell that if the person is there, tell the person to go out and leave. And then if they're not there, then you can tell them they're not working today, they're not here today. Sorry, that doesn't mean that if they don't believe you, that they now get to enter, right? That's not how that works. If the person is honestly not there, you tell them they're not here today. If they are there, don't tell them to run or hide. Have them leave the location and meet with the officer. And then again, have a number memorized, don't sign anything, ask to talk to a judge. They don't have to answer questions as far as what their immigration status or anything with ICE. However, if they have a work permit, just show it, right? Because you're going to cause more problems if you have the ability to work and you have a right to be here and you don't want to answer. But if people have that, just show it. Yep, see, I'm good. I'm good to go. Public places, like I said, anyone can go in there. It's parking lot, restaurant lobby, waiting areas. So being in a public area doesn't mean that ICE gets to stop every single person that's in that public area to ask questions. That just means they get to be there. And then they can't enter their private area without your permission. And like I said, put something up that says this is private, employees only, something so it's very clear on where they're allowed to go and where they're not allowed to go. So immigration agents can enter a private area only with the judicial warrant, not the ICE warrant, just the judicial warrant. Signed by a judge, US District Court, or a state court at the top. Generally, because it's ICE, they're usually gonna have a district court one, but not always. And then without a judicial warrant, ICE agents, they would need your permission to enter the private area of the business. And then if they try to enter, you can tell them, this is a private area, where's your warrant? What are you doing, basically? If they tell you they have a judicial warrant, ask them to see it and read it. Which again, you have a right to do, and they should be giving to you anyway. They can accept the warrant, but decline consent to a search if it's not listed in the warrant, right? So if the warrant says we're gonna check all of warehouse A, okay, you get to do that, but you don't get to wander over to warehouse B. It's not there, right? It's not in the warrant. Sometimes ICE agents use administrative warrants to enter, but it does not allow that. And again, you can tell it's an I-200, it's the form name. And it says specifically Department of Homeland Security on it. If you see that anywhere on there, besides like these people are allowed in there, you know, then red flags should start going off. So action plan. Don't open the door. Again, this is what I tell people if the people come to their house. If they don't have a warrant, like don't let them in if they don't have a warrant signed by a judge. Don't hand over an employee that ICE asks for if they don't have a warrant signed by a judge with that employee's name on it, right? So if they're looking for Susan over here, but they want to arrest Sally, don't give them Sally. They only get Susan. Don't answer questions or paperwork before contacting your attorney, just to make sure that everything is up to what it's supposed to be. I-9s, you only have to give, you have 72 hours to give it. You don't need to give it early. You can give it at that 72nd hour. And then ask the agents to identify themselves with their names and badge numbers. They won't always be cooperative about that, but you have a right to ask. You have a right to ask that with any law enforcement, technically, which they're not law enforcement, but you know what I mean. All right, so before we go into that, does anyone have any questions? It's a lot to take in, I understand. But like I said, I'm happy to share these slides with anyone. It's kind of a scary, volatile time for people. People are scared, but there's resources for people to help them. And I know that, you know, the hospitality industry here in Moab is vital. So it's good to be informed and to know how to help your employees, for sure. So I'm going to have Rihanna actually do this part. Surprise!
Okay,
You just tell me when to switch.
great. We recently did a press release. So I just put a picture of the Sun News article about Emily opening up her practice. So it's the intro slide. I looked in our database, and in the last 10 years, we've done over 1,500 hours of legal services with Emily. So that was really interesting for me to find. And so, yay. High five emoji.
Right.
Or 2 high five. So like I said, we've been working together for over 10 years. And Moab should be proud because this community really supports the center. I see some employers here who have definitely supported us, and we have grown together with this community, and we are absolutely still the first and only immigration legal service center in southeastern Utah that has free and low bono immigration legal services. So I'm really proud to have had a hand in that and to be working with Emily. So that's great, because that means that people are not, you know, here in rural Utah, we have to travel far a lot for medical care, for legal services sometimes. So it's really nice to have some of these specialized services here, right, in our own community.
Mm-hmm.
So,
and I can tell me people are like, yeah, I'm actually in Moab. What? And they're really excited.
well,
It's not like
that's, you know, this started, like many things do, out of a pure need. She mentioned that she worked at Catholic Community Services. They used to have this phone line. So when clients would come in needing immigration legal services, CCS had this
Wednesday phone line where you could call and get an immigration attorney. So we would have clients with these immigration legal needs. So I had the client be like, hey, let's call the Wednesday line to get the legal clinic. And, it was like the longest hold, and maybe you'd get somebody and then you'd wait for a call back. And I'm like, this isn't working. I have clients that need information now. And, yeah, it was just really impersonal, to get whoever was going to call. And then, of course, if you didn't get all the information in that one question, yeah. So it was fortuitous that Letty met Emily, and we were like, can we pay you to just, when we need some legal advice? So that was born truly out of need. And I had a conversation actually a couple weeks ago with a budding new little organization that is trying to help some people over in Southwestern, over on the other corner of our state. And I was kind of telling her about how we started, because she's like, how do you do that? I was like, well, this is how we started, because they don't have anything like we have here in Moab. And she was just like desperately trying to get, some attorneys to give some pro bono or low bono advice from Salt Lake. And I was like, well, if you can get somebody like we got, you just have to start small and kind of go from there.
Yep. It's been great.
Yeah. So, and like I said, the center does all these things. So grateful for the grant support and the community, donations that help these legal resources. This is our recently revised list of legal services that Emily supervises all of our immigration legal services. And they have kind of evolved and changed over the years. We just redid all of our intake paperwork and everything that we do when we meet and do intakes for immigration legal services. But this is what MBMC does. We only do a pretty specific scope of things because, like she just said, immigration law is super broad. So we try to give referrals and connect people to what they need, but what we can help with directly is pretty specific. One thing that we do are those deferred action for childhood renewal applications. $100. We do, it's like a document clinic. MBMC staff is trained to do those applications with people. And then Emily reviews the application for accuracy and they turn those into USCIS. That's a steal in terms of like being able to not pay a private attorney. And we have quite a few DACA kids in our community. So it's great that they can come to MBMC and get that done with attorney review super affordably and keep their employment authorization going. So that is awesome that we're able to do that. Green card renewal also, we do a good handful of these. This also is, sometimes Emily mentioned when somebody needs to, they might have adjusted through a family member and they are getting those conditions taken off of their green card and getting their permanent green card. That might be that situation. Or it might be that their actual green card is expiring and they need to renew that. So this is a fairly straightforward, if they don't have they didn't have any complications since their last renewal, MBMC can also help with this application with attorney review for just $100. Naturalization, this is awesome. I've done quite a few. I've helped a lot of members of our community naturalize over the last 10 years. It's a little bit of a longer application, and there's a little bit more involved, like Emily mentioned today with the test and all of that. But MBMC was also involved in a project last year with the GOEO, Governor's Office of Economic
Opportunity.
Where we were involved in something called the Utah Citizenship Initiative. Our current governor is aware that the state of Utah has something in the ballpark of between 40 and 50,000 eligible lawful permanent residents in our state that could naturalize, that haven't. And, you know, for some people, they don't have quite the proficiency in the English yet. For other people, a civics exam is, you know, pretty daunting, and then they just went and made the test harder. So we were involved in a project where we were offering like free exam prep in partnership with another organization up north, and we were waiving this $100 here all year last year. So yeah, but we've been doing naturalization for a really long time. Immigration benefit and risk assessment. Last year and this year, there's been an increase in clients and community members coming to the MVMC, just, you know, concerned about their safety and their family. So this is something that Emily and I put together, tailored a pretty comprehensive intake that our staff can do with anybody, and it's free. That not only is it a risk assessment that's individualized to that person for their own situation, but it also can tell them what benefits they might be available for them as well. They might you know, be eligible for some of these immigration, you know, hey, they might be able to get a U visa, or they might have a family member that they could file a petition through. So we, through a grant we're paying, MVMC staff does this risk assessment for free, and then we pay Emily to follow up with them with this analysis. So that's new this year. That's great. The intake and connection to legal services, that's kind of like anybody with any general like immigration question, they just come to MVMC. We have sort of a general intake, and we're like, okay, you know, tell us what your general question is, and based on that would be a referral to Emily, or maybe just, you know,
Immigration attorney.
Yeah.
He does criminal law and immigration.
Exactly.
I don't do that.
Yeah, she doesn't do you know,
Not yet anyway. I'm like,
yeah, criminal defense, or sometimes we can, you know, give them a kind of a straightforward answer, or that might sometimes lead into the next thing, maybe some kind of support services. Sometimes somebody's immigration situation is leading to a need for support services, sometimes in the community, they might have a family member that has been deported, that is leading to that half of their household income has been cut in half. So now they're having a hard time meeting rent and food and basic needs. So then we can talk about what MVMC we can support them, or what other resources might be available to them in the community. And then we can also, if they have any private attorney, or if they're representing themselves on any case, we can get them connected to Emily for fingerprint appointments or USCIS appointments. She can just do those one-off of things too, if somebody just wants to hire her to go to those USCIS appointments. So that's another great single service that we offer.
Yeah.
And then, you know, how does this benefit our business community? I would say, you know, obviously just having a community resource center that offers a really wide range of support services is great for your employees, right? I mean, we have a food pantry, we have homeless services, we do medical advocacy. Hopefully is something that can ease the burden and stress of your staff if they ever find themselves in need, that they can come to the center. And a long time ago, we're 19 years old now, the Multicultural Center. And when we originally started, you know, we were really an immigrant resource center, but we serve everybody. So I hope that has long been, I feel like everybody comes in, and not just immigrants now, but I hope that there's nobody out there that thinks that, oh, only immigrants can get help at the Multicultural Center, because we serve everybody. So lots of anybody can come get help here from the community. Also, we have 5 trained interpreters. So if you need language access for your business, I know a couple of you here have utilized our interpreters. So please call us for that. We do a lot of that here in the community. And then volunteer opportunities. So I think that's important for civil engagement for any community having that available. So those are ways I hope that we are good. And we're also members of the chamber, so I hope those are ways that we're good partners with the business community.
And it's been good too, because oftentimes people think we get taken advantage by notarios, that's what we call. Not actual attorneys that will say, yeah, you need to file this, you just need to do this. They'll pay a ton of money, and now they just got themselves put in deportation court because they didn't actually qualify for anything. And so people don't know me, but they know Rihanna, right? They know Zaida, they know everyone over there, Bradia. And so having that connection where you can say, no, trust her. I know attorneys sometimes can be shady, but she's reliable. So I try to be, and I will be 100% honest with people. And if I think that they're eligible for something or not, I'm not going to just take people's money. I definitely give clients that go through MVMC a huge discount on my services, because a lot of the times they need a lot of help. So it's been a great partnership for me too, just because I've been able first to come down to Moab a lot more, but also to help the community where I probably wouldn't be able to on a normal basis. So that's been good for us. While you're here, we wanted to bring up House Bill 136, sorry. I kind of threw this little summary together quickly.
Great.
It's huge though. We're not gonna go through all of it because it's giant. So it was during this last session, basically people that have valid driver's license, privilege card, or learner permit, if they don't have one of those, then their car could be towed. It happens like with DUIs, right? People's cars get towed when they have a DUI. But this is if you don't have any way to show that you have the ability to drive a car. So driver privilege card is the big one, right? But why is that a problem?
Who here knows what a driver privilege card is?
Is it like an international driver's license?
No, it is, so Utah we have like 4 different types of driver license credentials here in Utah. We have the Class D, which most of us have. It's like valid for 6 years. Then there's a limited term if you have like a visa, or you can,
DACA kids will have those.
Yeah, DACA, you can show like, okay, this is, I have status, permission to be here for a specific amount of time. You can get a limited term. Then of course there's a CDL and a permit, I guess, is another type. But a privilege card is something that they created for if you are in between status or you don't have status, you have to have an individual tax identification number, you have to get fingerprinted, and you have to show driving. You have to pass the driving test, both physical and a written exam in English. It's really difficult because the test is really hard. Sometimes it's 50 questions if you haven't had a driving credential in another country or state, and it's 25 questions otherwise. And I have clients who have taken this test 20 or more times and not been able to pass. And also it's right now it's an infraction, and they have raised in July, which we'll probably go over what's going to happen in July, but we have a lot of unlicensed drivers. Basically, this is more common than just a general speeding ticket. And I don't know what's going to happen. I think it's going to be really bad for our community if everybody starts getting their cars towed.
Yeah. Part of it is they have also doubled the fine for not having a license.
More than doubled. It went from $200 to $500.
So to $500 for not having it. First was an infraction, second is a Class B. Your car could get towed. It's $660 to get that car out, plus storage fees to the towing company. Yes.
So if I'm understanding this correctly, like instead of saying, oh, you're an unlicensed driver, is there somebody else that can come and pick up the vehicle for you? It's mandatory. It has to be towed, even if
The-
there is a licensed driver available.
No,
If there's
there's
like a
exceptions.
driver available,
Okay.
yeah, that's would be an exception.
Okay.
So exceptions, a couple of exceptions are if you have someone else that can come pick it up that has a license,
Mhm.
right? Then they can come pick up the car for you. They won't tow the car if it puts the officer at risk or it's a public safety issue or something like that. But what does that mean, I guess, is my concern. Personally, to me, you're in the middle of nowhere, that's a public safety concern, right? Like someone's not a car. It's snowing, it's raining, it's, it's hot.
Nighttime.
It's nighttime. The person has, they use a walker, they use a cane, stuff like that. Like there's different things that I think can come into play here. We went over this actually with Grant Miller. He's a Utah legislator. This is his first year. He's a brand new one, but he was saying that he's not sure how much officers are actually going to want to have to do this because it's a lot of time, right? You have to call it, touch so we're not sure how much it's going to happen, but it definitely has a bigger ripple effect out here as opposed to in Salt Lake.
Because there's no public
Because
transportation.
there's no public
here.
transportation. And if you're paying $500 for the ticket, $660 for the impound, plus storage fees, and you can't work because you need your car to work, how is that? No, how's that gonna work? So it's kind of a concern that has popped up for us.
Do you know how many of these are in court in our justice court every single week?
No
At
license.
least 5 to 10. Like, this is a really common, this is so common, like very common.
Because getting the card is really difficult. Because it's a difficult test if you don't have a high education. It's a difficult test if you're not a native speaker. So being an English only is a huge issue. But that was the couple exceptions. If you have a foreign driver's license, you're okay. If you have an out-of-state driver's license, you're okay. You just have to show that you have something that gives you the ability to operate a vehicle. The other part that they're doing it is running fingerprints for people. My concern as an immigration attorney is that get moved over to ICE? Are they going to call ICE? Police officers will run people's identity, right? Make sure there's not a warrant out or anything like that. But taking a fingerprint is a concern. Is that where does that go? Who controls that database? I think is a big concern. They don't. In July is when that's going to start. Impounding vehicles is when that's going to start. Technically, on the 3rd of May, this will come into play where they can give infractions to a Class B. Towing won't start until July. Fingerprints technically can start in July, but basically they're saying all law enforcement agencies need to give people a portable fingerprint, all officers a portable fingerprint thing to carry with them. And that has to be done by July 1st or January 1st, 2028. Who's paying for that?
How much do they cost?
I don't know. And they said that you have to get a software agency. Well, okay, well,
Yeah.
there's a lot of things that weren't really.
So are you saying that they'll be law enforcement required to do a digital?
Yes.
fingerprint? Okay, because I was gonna say, we do fingerprints now.
Yeah.
If it's a Class B or above, it's an ink pad,
Right, yeah,
and that goes to USCIS, then where it goes from USCIS,
right.
BCI basically in Utah,
Mhm.
where it goes, who has access to their system, I don't know.
Right.
No, this will be like mobile, like on
The person.
traffic stop.
Yeah.
Fingerprinting.
Well, that's gonna be expensive.
Yeah.
Yeah. No
Yeah.
kidding.
And there's ways that the officer doesn't have to do that. Like if they have any sort of ID, even if it's foreign, like a passport, then they don't need to fingerprint. It's just that if they carry nothing with them, then they can fingerprint them, but it's expensive to buy those for every single police officer. So it'll be interesting and see how that goes. But we just kind of want to make you aware that if you have workers that aren't showing up because their car got impounded, this might be why. So one thing that we're trying to do, sorry, one second. One thing that we're trying to do, there's a couple organizations, there's 2 police officers, one in Park City, one in West Jordan, that they give classes on how to do the driver privilege card, how to get it. We're gonna see if we can connect with them to try to get information out here, to help the community with that. But, encouraging, you know, your employees to try to do the driver privilege card, which is really hard if they can't pass the test. That's the
Yeah,
hard.
if they can, if they can get a DPC, get it. If they've let it lapse, renew it, get on it before July 1st. We're trying to get the word out now. MPMC is going to be creating a lot of education and outreach materials. We'll share them with the chamber. We're going to be meeting with law enforcement and the mayor. We're going to be doing as much outreach as possible because, like I said, this is such a common charge that we see in our courts. I can't imagine how much time law enforcement is going to be spending towing people's cars and how like economically this will affect people getting to work, and then just how expensive that this will be between the ticket and the tow fee, like over $1,000. It would be as devastating as like a DUI incident, you know, for simply driving without a license.
Yeah, and the safety concern, I mean, people are worried. When the DPC first started, they were sharing information with ICE at that time. They don't do that anymore. We've had promises from the DMV and the DLD that they were not gonna do that, and they haven't been. And so if that's people's hesitation because they think they're gonna share it with ICE, you can tell them, as far as we know right now, that's not happening. So, because they have to do that. But projected timeline, May 6th is when it takes effect for licensing and penalties. And then July is when the new impound and seizure protocols take effect. The tax commission, that's in December, but deadline for all law enforcement to be equipped with a biometric capture device has to be done by January 1st, 2028. So that's kind of, we just want to give you a heads up on that. That's coming down the pipeline. All right, any questions on that? Yeah.
I just want to clarify. So this is like a new House bill that passed.
Just passed.
And the
yeah,
governor
brand new.
signed it, and he signed it, so it's coming into effect.
How many states have